Welcome to our deep dive on immigration fraud reports. Do they matter, and who is truly listening? First, we will set expectations and lay out a clear path through a complex and often misunderstood process. Then, we will cover which agencies actually act on fraud tips, what evidence is required, how timelines work, and how filing a report may or may not affect family court. Finally, we will walk through practical steps to report responsibly, followed by key takeaways and a quick quiz to test your knowledge. Here is our roadmap for today. First, motivations for reporting. Next, agency roles and who actually listens. Then, evidence standards. After that, we will explore the impact on family court. We will also discuss risks and ethics, provide a realistic how-to guide, examine typical timelines, and close with key takeaways. Before we begin, an important disclaimer. This content is for general informational purposes only and does not constitute legal advice. Laws and procedures can change, and every case is fact-specific. You should consult a qualified immigration or family law attorney before taking any action. Let's start with why people file immigration fraud tips. Common motivations include seeking quick action or accountability, creating a written record that might be useful later in legal disputes, responding to perceived dishonesty or retaliation during a separation, protecting children or finances, and the belief that authorities will immediately investigate. However, these expectations often run into the realities of limited resources and strict evidence requirements. Now let's move through the bureaucratic maze. Authorities receive thousands of tips each year. Many lack substantiation or are filed in the context of personal disputes. As a result, most tips are logged into databases for future reference, rather than actively investigated. An investigation typically proceeds only when there is strong, concrete evidence and when resources are available. Therefore, you should expect little to no acknowledgment after filing, and understand that silence is common. Let us clarify roles. USCIS primarily adjudicates benefits and petitions. While it may note fraud indicators, it is not the primary enforcement body. In contrast, Homeland Security Investigations is the enforcement entity that investigates immigration and related crimes, conducts field operations, and coordinates with prosecutors. If the goal is immediate enforcement, directing a well-supported tip to HSI rather than expecting USCIS to act is crucial. This timeline illustrates that after submission, a tip often undergoes an intake and triage phase with no acknowledgement. Many tips are simply logged, only those with compelling evidence, and when resources permit, move to analyst review and potentially to an investigation. Outcomes range from no action, to administrative notes, to interviews or site visits, or even referrals for prosecution. The key takeaway is that this process can span many months, if not years. Evidence is the highest hurdle. Strong evidence includes bank statements, contracts or receipts linking payments to a sham marriage, written communications admitting the scheme, consistent dated messages, and third-party corroboration. Weak indicators include rumors, hearsay, or accusations filed during conflicts such as separations. Filing immediately before family court may appear retaliatory. Risky conduct, such as fabricating proof, stalking, harassment, or illegal recordings, can severely damage credibility. For documentation, retain originals and metadata. Organize a clear factual timeline, and avoid speculation. Focus on verifiable facts. This table summarizes evidence value. Strong evidence includes traceable financial transfers linked to arrangements, written admissions, and corroborated timelines. Moderate evidence includes inconsistencies and suspicious patterns that still require corroboration. Weak evidence includes anonymous or vague claims and reports filed strategically near custody hearings. Risky or illegal methods harm credibility and may expose the accuser to legal issues. Turning to family court, the primary focus is the child's best interests. Immigration status, or past financial crimes, typically matter only when they affect the child's safety or stability. Judges may view last-minute immigration fraud reports, especially those filed just before a hearing, as tactical or retaliatory. A report alone is merely an allegation and not a determination of wrongdoing. Its direct impact is limited, unless the conduct directly endangers the child. Quiz time. Which agency primarily handles active immigration fraud investigations and enforcement actions? Option A, USCIS. Option B, Homeland Security Investigations, HSI. Option C, Department of State Consular Affairs. Option D, Social Security Administration.
You may pause the video now to think about the answer.
We will discuss the answer in the next section of the video. The correct answer is Homeland Security Investigations, HSI.
USCIS handles adjudication of benefits and petitions, while HSI leads enforcement and investigations. Here are practical steps to report responsibly. First, gather lawful, concrete evidence. Second, send your tip to the correct channel, such as HSI's tip line, rather than expecting USCIS to take enforcement action. Third, write a concise, factual summary with dates and attach organized exhibits. Fourth, avoid retaliatory language and stick to verifiable facts. Fifth, manage expectations and anticipate no acknowledgment for a long period. Sixth, prioritize safety and legality. Do not harass or surveil anyone. Seventh, consult an attorney, particularly if you have a pending or upcoming family court matter. This decision tree helps you assess whether to submit a report now. It starts with the presence of concrete, lawfully obtained evidence. If you lack it, focus on documentation and legal advice. If you have it, evaluate whether there is immediate risk to a child or serious criminal behavior. If so, a prompt report to HSI may be appropriate. If not, consider whether to gather more corroboration. If a custody hearing is imminent, recognize the risk of the report appearing retaliatory and consult your family law attorney. Regardless, report with facts only, expect no immediate response, and maintain safety and legality. Key takeaways include the following. Most tips are logged and only well-supported cases advance. USCIS adjudicates, while HSI investigates and enforces. Evidence should be concrete and lawfully obtained. Family court focuses on child welfare. Timing and intent can affect how your actions are perceived. Expect silence and extended timelines. Finally, consult qualified counsel, particularly when family court is involved. Second quiz. Will filing an immigration fraud report right before a custody hearing typically help your case? Option A. Yes, judges rely on these reports for custody decisions. Option B. No, it often appears retaliatory and has limited direct impact. Option C. Yes, if you also post about it on social media. Option D. It guarantees an investigation and swift action. You may pause the video now to consider your answer. We will discuss the correct answer in the next section.
The correct answer is no. Filing right before a custody hearing often appears retaliatory and typically has limited direct impact. Family court is focused on the child's best interests, and strategic timing can undermine your credibility. In summary, immigration fraud reports can matter when supported by strong, lawfully obtained evidence. Immediate responses are rare, so patience is necessary. Direct tips to the correct agency, with HSI handling investigations and USCIS adjudicating benefits.
In family court, the child's welfare and your credibility are paramount.
When in doubt, seek legal advice early.
Thank you for watching.
If this video helped, please like, share, and subscribe. Share your experiences and questions in the comments so others can learn from them as well.